Question 1. Federal and International Animal Law Endangered Species Act. ESA during a critical transition period where existing processes for species conservation are being reassessed, a dispute arises regarding a state's ability to regulate species listed under the Federal Endangered Species Act ESA. State agency argues that it has the authority to modify habitat protections for an endangered species within its jurisdiction. However, conservation group challenges this, claiming that federal law preempts state's decision. Which legal principle is most applicable in resolving this dispute? A. The doctrine of state sovereignty, which allows states full control over wildlife within their borders. B. The supremacy clause of the U.S. Constitution, which ensures that federal law overrides conflicting state laws. C. The public trust doctrine, which mandates that natural resources, including wildlife, are held in trust by the state for public use. D. The doctrine of primary jurisdiction, which requires courts to defer regulatory disputes to administrative agencies. Answer. B. The supremacy clause of the U.S. Constitution, which ensures that federal law overrides conflicting state laws. Explanation. Under the Endangered Species Act ESA 16 U.S. The SSS 1531-1544, the federal government has broad authority to regulate the conservation of endangered and threatened species. The Supremacy Clause, Article Romans Clause 2 of the U.S. Constitution, establishes that federal laws take precedence over conflicting state laws. Courts have consistently held that state regulations that undermine ESA protections are preempted by federal law. Tennessee Valley Authority v. Hill 437 U.S. 153, 1978. A. The doctrine of state sovereignty. Incorrect. While states typically have control over wildlife within their borders, the ESA explicitly overrides state law when conflicts arise. C. The public trust doctrine. Incorrect. While this doctrine applies to natural resources, it does not override federal conservation laws. D. The doctrine of primary jurisdiction. Incorrect. This doctrine applies when courts defer to administrative agencies but resolve conflicts between state and federal law. Question 2. Animals in agriculture and farming law. Factory farming regulations. In an environment where different components must interact efficiently, a large-scale poultry farm is accused of violating federal animal welfare standards. The farm argues that its operations are exempt from regulation under state agricultural laws, while an animal welfare organization cites federal laws governing humane treatment. Which of the following principles or regulations is most relevant in determining the farm's liability? A. The Animal Welfare Act, which sets federal standards for the treatment of farm animals in agricultural settings. B. The Humane Methods of Slaughter Act, HSA, which applies to the slaughter of certain livestock but not poultry. C. The Federal Meat Inspection Act, FMIA, which regulates meat processing plants and includes humane handling requirements. D. The Commerce Clause, which allows Congress to regulate agricultural activities. Impact interstate commerce. Answer. B. The Humane Methods of Slaughter Act, HSA, which applies to the slaughter of certain livestock but not poultry. Explanation. The Humane Methods of Slaughter Act, HSA 7 U.S. The SSS 1901-1907 requires that livestock be slaughtered in humane manner. However, key limitation of the HSA is that poultry is not covered under the Act. This means that while cattle, sheep, and pigs must be slaughtered using humane methods, federal law does not provide the same explicit protections for poultry. A. The Animal Welfare Act, incorrect. The 7 U.S.C. SSS 2131-2159 does regulate certain animals in research and exhibition, but it exempts farm animals used for food production. C. The Federal Meat Inspection Act, FMIA, incorrect. The FMIA regulates meat safety and inspection, rather than animal welfare in farming operations. D. The Commerce Clause. While the Commerce Clause, Article I, Section 8, Clause 3 of the U.S. Constitution grants Congress power over interstate commerce, it does not establish specific animal welfare protections. This question highlights key gap in federal animal welfare laws regarding poultry farming. Question 3. Civil law and animal law disputes. Veterinary malpractice during the introduction of new methods where coordination is essential. A pet owner sues a veterinarian for malpractice after a dog dies from complications following an experimental surgical procedure. The owner claims the veterinarian failed to disclose the risks, while the veterinarian argues that the owner consented to the procedure. Which legal doctrine is most relevant? Determining liability. A. Respondit superior, holding employers responsible for employees' negligent acts. B. Strict liability, which applies to inherently dangerous activities regardless of negligence. C. Informed consent, which requires professionals to disclose risks and obtain voluntary agreement from clients. D. Assumption of risk, which protects professionals if the client knowingly accepted dangerous condition. Answer: C. Informed consent, which requires professionals to disclose risks and obtain voluntary agreement from clients. Explanation: the doctrine of informed consent requires that professionals, including veterinarians, fully disclose all significant risks associated with a procedure so that clients can make an educated decision. The standard for informed consent in veterinary malpractice cases is derived from general tort principles similar to those applied in human medical malpractice cases. Nelson v. State Board of Veterinary Medicine, 154p.3-538, Colo, 2007. A respondit superior incorrect. This principle applies when an employer is held responsible for the actions of an employee but does not determine whether malpractice occurred. B. Strict liability. Incorrect. Veterinary malpractice falls under negligence law, not strict liability, which applies to inherently dangerous activities like keeping wild animals. D. Assumption of risk. Incorrect. While assumption of risk is a valid defense, it does not apply. Veterinarian failed to disclose material risks. Veterinary malpractice cases often hinge on whether the pet owner was adequately informed of potential risks before consenting to treatment. Question 4. In a high-stakes environment where multiple challenges must be addressed simultaneously, a state legislature is considering a bill that would strengthen anti-cruelty laws. The bill proposes increasing penalties for animal abuse, expanding enforcement powers for state agencies, and allowing private citizens to bring lawsuits against violators. However, a coalition of agricultural and research organizations strongly opposes the bill, arguing that it would conflict with existing exemptions for farming and laboratory testing. Given the complexity of these competing interests, which of the following legal doctrines is most relevant in determining whether the bill could withstand constitutional scrutiny? A. The Dormant Commerce Clause. B. The Rational Basis Test. C. Strict scrutiny. D. The void for vagueness doctrine. Answer: B. The Rational Basis Test. Explanation: the rational basis test is the appropriate standard of review in this case because most animal protection laws, including anti-cruelty statutes, do not implicate fundamental constitutional rights or suspect classifications, such as race or religion. Courts generally uphold laws regulating animal treatment as long as they are rationally related to a legitimate governmental interest, such as preventing animal cruelty. Dormant Commerce Clause A is incorrect because while it applies to state laws that may burden interstate commerce, courts have upheld state animal welfare laws unless they unduly discriminate against out-of-state businesses. Strict scrutiny C is incorrect because strict scrutiny is reserved for laws affecting fundamental rights, such as free speech or religious freedom, which is not the case here. Void for vagueness doctrine is incorrect because it applies when a law is so unclear that it fails to give people proper notice of what conduct is prohibited, which is not an issue with well-drafted anti-cruelty statutes. Relevant law: state anti-cruelty laws, agricultural exemptions, and judicial precedents such as United States v. Stevens, 2010, where the Supreme Court addressed the limits of animal protection laws under the First Amendment. Question 5. During a comprehensive review of a process that needs improvement, a city government is revising its regulations on dangerous dog breeds. The existing law bans ownership of certain breeds, including pit bulls and Rottweilers, citing public safety concerns. However, recent studies show that breed-specific legislation (BSL) is ineffective and unfairly targets responsible owners. What legal argument could best be used to the constitutionality of breed-specific legislation? A. Equal Protection Clause under the 14th Amendment. B. The Takings Clause of the 5th Amendment. C. The First Amendment right to free speech. D. The Privileges and Immunities Clause. Answer: A. Equal Protection Clause under the 14th Amendment. Explanation: breed-specific legislation can be challenged under the Equal Protection Clause if it is shown to be arbitrary and not rationally related to legitimate government interests. Courts in some jurisdictions have ruled that BSL fails rational basis review because it does not effectively reduce dog attacks and discriminates against responsible owners of certain breeds without justification. The Takings Clause B is incorrect because while banning certain breeds may affect property rights, courts have generally not considered pet ownership as a taking requiring compensation. First Amendment: C is incorrect because the law does not regulate speech or expressive conduct. Privileges and immunities clause D is incorrect because this clause protects against discrimination between residents of different states, which is relevant to a municipal dog law. Relevant case, American Dog Owners Assand v. Dade County, 1989, where the court examined the constitutionality of BSL but ultimately upheld the law under rational basis review. Question 6. While investigating a complicated issue between different industries, Congress is considering an amendment to the Endangered Species Act (ESSA) that would allow for economic considerations when deciding whether to list a species as endangered. Conservationists argue that this change would weaken the law's core purpose of protecting vulnerable species. Which of the following principles best supports their argument? A. The precautionary principle. B. The market efficiency theory. C. The rule of lenity. D. Federalism doctrine. Correct answer. A. The precautionary principle. Explanation. The precautionary principle holds that when an activity raises threats of serious or irreversible harm to the environment, lack of full scientific certainty should not be used as a reason for postponing protective measures. The ESSA was designed to prioritize species survival over economic concerns, which is why courts have consistently interpreted it as prohibiting economic factors from influencing listing decisions. Tennessee Valley Authority v. Hill, 1978. Market efficiency theory B is incorrect because economic efficiency is not the guiding principle of the ESSA. Rule of lenity C applies to criminal law and would not be relevant here. Federalism doctrine D deals with the division of power between state and federal governments, which is a broader issue. Question 7. When implementing new protocols in a shared environment, a state's animal control agency proposes rule requiring shelters to hold stray animals for at least 10 days before euthanasia. This is longer than the previous 5-day requirement. However, shelter operators argue that the extended holding period increases overcrowding and strains their resources. Which legal principle would most likely determine whether the extended period is enforceable? A. The Administrative Procedures Act (APA). B. Strict scrutiny under constitutional law. C. The common law doctrine of necessity. D. The Eighth Amendment's cruel and unusual punishment clause. Answer. A. The Administrative Procedures Act (APA). Explanation. Regulations enacted by agencies must comply with the Administrative Procedures Act (APA), which ensures that rulemaking follows proper procedures, is not arbitrary or capricious, and has a rational basis. If the agency followed proper rulemaking procedures and has a reasonable justification for extending the holding period, courts would likely uphold the rule. Strict scrutiny does not apply here because no fundamental rights are at stake. Common law doctrine of necessity C applies in emergency situations, not administrative rulemaking. The Eighth Amendment D is incorrect because it applies to criminal punishment, not animal control policies. Relevant law: state animal shelter and euthanasia regulations and APA case law on rulemaking challenges. Question 8. In a high-stakes environment where multiple challenges must be addressed simultaneously, a state wildlife agency introduces a regulation prohibiting the use of certain hunting traps known to cause significant animal suffering. However, a coalition of hunting organizations files a lawsuit arguing that the rule violates their constitutional rights. Which of the following legal arguments would most likely be relevant in determining the validity? Regulation A. The Commerce Clause. B. The Due Process Clause of the 14th Amendment. C. The Second Amendment right to bear arms. D. The Public Trust Doctrine. Answer. D. The Public Trust Doctrine. Explanation. The Public Trust Doctrine holds that certain natural resources, including wildlife, are preserved for public use and that the government has a duty to manage them responsibly. Courts have upheld wildlife protection laws based on this doctrine, ruling that states have the authority to regulate hunting practices to ensure conservation and humane treatment of animals. Commerce Clause A is because the regulation does not directly restrict interstate commerce. Due Process Clause B does not apply here, as the law does not deprive hunters of a fundamental right without due process. Second Amendment C is incorrect because hunting regulations do not impact the right to bear arms, but rather the methods of hunting. A relevant case, Gier v. Connecticut, 1896, which upheld state control over wildlife resources. Question 9. During a comprehensive review of a process that needs improvement, a city council debates whether to pass an ordinance requiring all pet stores to source their animals from shelters or rescues instead of commercial breeders. Opponents argue that this violates the principles of free trade. Which legal framework would most likely determine the ordinance's constitutionality? A. The Dormant Commerce Clause. B. The Equal Protection Clause. C. The Federal Animal Welfare Act. D. The Endangered Species Act. Answer: A. The Dormant Commerce Clause. Explanation: the Dormant Commerce Clause prohibits states and municipalities from enacting laws that unduly burden interstate commerce. Courts have struck down laws that discriminate against out-of-state businesses, even if they serve legitimate local interests. If the ordinance disproportionately affects out-of-state breeders without a strong justification, it could be unconstitutional. The Equal Protection Clause B does not apply because there is no suspect classification. Federal Animal Welfare Act C regulates the treatment of animals, but does not control local sales laws. Endangered Species Act D is irrelevant since the law does not deal with protected species. Relevant case: National Pork Producers Council v. Ross 2023, which examines state restrictions on animal product sales under the Commerce Clause. Question 10. While analyzing the root causes of sequential problems in animal agriculture, Congress considers a bill requiring stricter environmental regulations for large-scale livestock operations due to their impact on public health and ecosystems. Which federal statute is most relevant to determining whether these operations must comply with stricter environmental oversight? A. The Clean Water Act. B. The Animal Welfare Act. C. The Freedom of Information Act. D. The Lacey Act. Answer: A. The Clean Water Act. Explanation: the Clean Water Act regulates pollution discharges into water bodies, including agricultural runoff from concentrated animal feeding operations. COFOs, livestock operations that discharge pollutants into waterways require permits under the COA, making it the most relevant statute for determining regulatory oversight. Animal Welfare Act B governs treatment of animals but does not regulate environmental impact. Freedom of Information Act C concerns government transparency, not environmental regulation. Lacey Act D deals with illegal wildlife trade rather than pollution control. Relevant case: Waterkeeper Alliance v. EPA 2005, which upheld COFO regulation under AU. Question 11. When implementing new protocols in a shared environment, an airline enforces a rule prohibiting emotional support animals (ESAs) from flying in the cabin. A disabled passenger challenges the policy, claiming it violates federal disability laws. Under which statute would the airline's policy be evaluated? A. Americans with Disabilities Act (ADA). B. Air Carrier Access Act (ACAR). C. Fair Housing Act (FHA). D. Animal Welfare Act (OWA). Answer: B. Air Carrier Access Act (ACAR). Explanation: the Air Carrier Access Act (ACAR) regulates airline accommodations for passengers with disabilities, unlike the ADA, which covers public places. The ACAR specifically applies to air travel. The Department of Transportation has ruled that airlines must accommodate service animals but may restrict emotional support animals. ADA applies to general public accommodations, not airlines. FHAC covers housing, not air travel. AWAT-D governs animal welfare standards but does not address disability accommodations. Relevant case: Department of Transportation 2020 ESA rule, which allowed airlines to ban ESAs in cabins. Question 12. In an environment where different components must interact effectively, a national zoo is sued after an escaped tiger injures a visitor. The lawsuit claims the zoo was negligent in maintaining adequate containment measures. Which legal principle would be most relevant in determining liability? A. Strict liability for wild animals. B. Premises liability. C. The Animal Welfare Act (AWAT). D. The Endangered Species Act (ESA). Answer: A. Strict liability for wild animals. Explanation: under strict liability, owners of wild animals are held responsible for any harm caused by those animals, regardless of negligence. Since a tiger is an inherently dangerous animal, the zoo could be held liable even if they took reasonable precautions. Premises liability B applies to general property hazards but does not override strict liability for wild animals. Animal Welfare Act C regulates animal care standards but does not determine liability for injuries. Endangered Species Act D protects species but does not address personal injury claims. Relevant case: Palumbo v. State Game Commission 1992, where a state agency was held liable for wild animal injuries. Question 13. During the introduction of new methods where coordination is crucial, a food processing company adopts new slaughterhouse techniques that comply with state law but conflict with federal humane slaughter regulations. Which legal doctrine determines whether the federal law overrides the state law? A. The doctrine of preemption. B. The Dormant Commerce Clause. C. The Equal Protection Clause. D. The Agricultural Exemption Doctrine. Answer A. The doctrine of preemption. Explanation. Under the Supremacy Clause of the U.S. Constitution, federal law preempts conflicting state law if Congress has expressed clear intent to regulate an issue. The Humane Methods of Slaughter Act (HSA) sets national standards, meaning state laws in conflict with federal slaughter requirements are invalid. Dormant Commerce Clause B deals with trade restrictions, not conflicting laws. Equal Protection Clause C concerns discrimination, not regulatory conflicts. Agricultural Exemption Doctrine D relates to tax and labor laws, not slaughter regulations. Relevant case: National Meat Sock v. Harris 2012, where the Supreme Court ruled that California's slaughter regulations were preempted by federal law. Question 14. While examining inconsistencies across various units, a marine wildlife center applies for a permit to rehabilitate injured sea turtles, but the federal government denies the request, citing conservation priorities. Under which law does the government have the authority to restrict such permits? A. The Marine Mammal Protection Act (MMPA). B. The Endangered Species Act (ESSA). C. The Lacey Act. D. The Migratory Bird Treaty Act (MTA). Answer B. The Endangered Species Act (ESSA). Explanation. The Endangered Species Act (ESSA) governs the protection of species classified as endangered or threatened. Since sea turtles are protected under the ESSA, the government has the authority to regulate rehabilitation efforts. Marine Mammal Protection Act A applies to marine mammals like whales, not sea turtles. Lacey Act C focuses on wildlife trafficking, not conservation permits. Bird Treaty Act D protects birds, not reptiles. Relevant case: Loggerhead Turtle v. Volusia County 1998, which upheld restrictions on activities affecting endangered species. Question 15. In a situation where formal requirements conflict with ethical considerations, a pharmaceutical company uses animals for testing new medications. An animal rights organization files a lawsuit arguing that alternative testing methods should be mandated. Under which law is animal testing primarily regulated? A. The Animal Welfare Act (WAP). B. The Food, Drug and Cosmetic Act (FDA). C. The Endangered Species Act (ESSA). D. The Freedom of Information Act (FOIA). Answer A. The Animal Welfare Act (WAP). Explanation. The Animal Welfare Act (WAP) is the main federal law regulating animal testing in research facilities. It establishes minimum standards for humane treatment but does not ban animal testing. FDA B regulates drug approval but does not set animal welfare rules. SSC applies only if an endangered species is involved. FOIA D allows access to government records but does not regulate animal testing. The relevant case: Physicians Committee for Responsible Medicine v. the year 2004, which challenged animal testing practices. Question 16. During a seamless transition where continuity must be maintained, a city passes an ordinance requiring all new buildings to include bird-friendly design features to reduce window collisions. A property developer challenges the ordinance, arguing that it interferes with their right to design buildings as they see fit. What legal principle supports the city's authority to impose such a rule? A. The police power of the state. B. The takings clause. C. The right Farm Act. D. The Dormant Commerce Clause. Answer A. The police power of the state. Explanation. Police power allows governments to regulate public health, safety, and welfare, including environmental concerns. Courts generally uphold zoning and building regulations as legitimate exercises of this power. Takings clause. B applies only if the government seizes property without compensation. Right to Farm Act. C protects farmers, not developers. Dormant Commerce Clause. D is as the law does not impact interstate trade. Relevant case: Murr v. Wisconsin 2017, which upheld state regulatory powers. Question 17. While managing a hybrid approach where timing issues affect coordination, an international conservation group ships wildlife rescue supplies across multiple borders. Which treaty ensures the legal trade and transport of endangered species while preventing illegal trafficking? A. The Convention on International Trade in Endangered Species CITES. B. The Lacey Act. C. The Migratory Bird Treaty Act MTA. D. The Marine Mammal Protection Act MPA. Answer A. The Convention on International Trade in Endangered Species CITES. Explanation. CITES is an international agreement ensuring that trade in endangered species is legal and does not threaten their survival. It regulates permits for the import-export of protected wildlife and products. Lacey Act B focuses on illegal trafficking but is a US law, not a treaty. MTA C protects migratory birds but does not regulate international trade. MPA D applies only to marine mammals. Relevant case United States v. Benges 2012, which enforced site-related wildlife trafficking laws. Question 18. In a multi-location scenario where consistency requirements must be enforced, a fast food chain advertises its products as humanely raised despite sourcing from industrial farms. Which legal doctrine could be used to challenge this misleading claim? A. Consumer protection laws on false advertising. B. The Lanham Act on trademarks. C. The Right to Farm Act. D. The Freedom of Speech Clause. Answer A. Consumer protection laws on false advertising. Explanation. False advertising laws prevent companies from making deceptive claims about product sourcing or animal welfare. Regulators and consumers can sue companies that mislead the public. Lanham Act B protects trademarks but does not regulate marketing claims. Right to Farm Act C protects farmers from nuisance lawsuits, not false advertising. Freedom of speech does not protect deceptive commercial speech. Relevant case Peta v. Whole Foods 2017, which challenged misleading humane labeling. Question 19. While analyzing the root causes of sequential problems in wildlife conservation, a state government imposes a strict ban on all hunting, including regulated seasonal hunting. A group of hunters challenges the ban, arguing that it violates their rights. Under what legal principle could the state defend its decision? A. The Public Trust Doctrine. B. The Second Amendment. C. The Commerce Clause. D. The Right to Farm Act. Answer A. The Public Trust Doctrine. Explanation. The Public Trust Doctrine holds that natural resources, including wildlife, belong to the public and that the government has the duty to manage and conserve them for future generations. Courts have upheld state-imposed hunting restrictions as a valid exercise of state authority to protect ecosystems. Second Amendment B protects the right to bear arms but does not guarantee unrestricted hunting. Commerce Clause C governs interstate trade, not wildlife protection. Right to Farm Act D applies to agricultural protections, not hunting. Relevant case Gier v. Connecticut 1896, which upheld state control over wildlife resources. Question 20. When implementing new protocols in a shared environment, an airport plans to introduce drone surveillance for security purposes. Privacy advocates argue that the constant surveillance violates citizens' rights. Which constitutional principle applies to this case? A. The Fourth Amendment. Protection against unreasonable searches. B. The Takings Clause. Eminent domain. C. The First Amendment. Freedom of speech. D. The Privileges and Immunities Clause. Answer A. The Fourth Amendment. Protection against unreasonable searches. Explanation. The Fourth Amendment protects against unreasonable government searches and seizures. Courts have ruled that warrantless aerial surveillance can infringe on individual privacy if it collects information without legal justification. Takings Clause B concerns government seizure of property, not surveillance. First Amendment C protects speech, not privacy rights. Privileges and Immunities Clause D ensures fair treatment across states, but is irrelevant here. Relevant case Carpenter v. United States 2018, where the Supreme Court ruled that government tracking of private information requires warrant. Question 21. In a high-stakes environment where multiple challenges affect decision-making, a company producing eco-friendly products falsely claims that its packaging is 100% biodegradable. Which law would apply to a lawsuit against the company for misleading consumers? A. The Federal Trade Commission Act FTC Act. B. The Environmental Protection Agency EPA Clean Water Act. C. The Sherman Antitrust Act. D. The Freedom of Information Act FOIA. Answer A. The Federal Trade Commission Act FTC Act. Explanation. The FTC Act prohibits false and deceptive advertising. Companies that make misleading environmental claims can face penalties under the FTC's Green Guides, which require that sustainability claims be scientifically verifiable. EPA Clean Water Act. B. Regulates water pollution, not advertising. Sherman Antitrust Act. C. Deals with monopolies, not consumer fraud. FOIA. D. Allows access to government documents but is irrelevant here. Relevant case: FTC v. Volkswagen 2016, where Volkswagen was penalized for false environmental claims. Question 22. During a comprehensive review of a process that needs improvement, an animal rights organization challenges the use of exotic animals in traveling circuses, arguing that it violates federal welfare laws. Under which statute could this challenge be filed? A. The Animal Welfare Act (AWAC). B. The Migratory Bird Treaty Act (MTA). C. The Endangered Species Act (ESSA). D. The Federal Insecticide, Fungicide and Rodenticide Act (FIFRA). Answer: A. The Animal Welfare Act (AWAC). Explanation: the Animal Welfare Act (AWAC) regulates the treatment of animals used in research, exhibitions, and commercial businesses, including circuses. Organizations can file complaints under the AWAC if circuses mistreat animals or fail to meet care standards. MTA. B. Protects migratory birds, not circus animals. ESSA. C. Applies only to endangered species. FIFRA. D. Regulates pesticide use, not animal welfare. Relevant case: PETA v. Feld Entertainment 2014, where animal rights group sued at circus for elephant mistreatment. Question 23. In a situation where resource allocation comes a challenge, a state government proposes a new hunting permit system that gives preference to residents over non-residents. A group of non-residents sues, claiming discrimination. What constitutional principle is at stake? A. The Privileges and Immunities Clause. B. The Takings Clause. C. The Dormant Commerce Clause. D. The Equal Protection Clause. Answer: A. The Privileges and Immunities Clause. Explanation: the Privileges and Immunities Clause, Article Omen, Section 2, prevents states from discriminating against non-residents in economic activities. Courts have ruled that hunting permits cannot unfairly favor state residents over others. Takings Clause. B. Applies to property seizures, not discrimination. Dormant Commerce Clause. C. Applies to trade restrictions, not hunting rights. The Equal Protection Clause. D. Protects against discrimination but is less relevant here. Relevant case: Baldwin v. Fish and Game Commission of Montana 1978, which upheld the state's right to differentiate on hunting licenses. Question 24. During an emergency response where multiple areas are impacted, a chemical plant spill contaminates a river that supplies drinking water to multiple states. Which federal law governs the company's liability for the cleanup? A. The Comprehensive Environmental Response, Compensation, and Liability Act (CERCLA). B. The Clean Water Act (CA). C. The Toxic Substances Control Act (TSCA). D. The Occupational Safety and Health Act (OSHA). Answer: A. CERCLA. Explanation: CERCLA, also known as Superfund, holds companies strictly liable for hazardous waste cleanup in cases of environmental contamination. B. Regulates water pollution but does not assign liability. TSCA. C. Governs chemical safety but does not cover cleanup liability. OSHA. D. Ensures workplace safety, not environmental protection. Relevant case: U.S. v. Best Foods 1998, which held a parent company liable for pollution cleanup. Question 25. When scaling up operations that experience significant environmental impacts, a developer wants to build in a protected wetland area. Which federal law requires an environmental impact assessment before approval? A. The National Environmental Policy Act (NEPA). B. The Endangered Species Act (ESSA). C. The Clean Air Act (CA). D. The Marine Protection Act. Answer: A. NEPA. Explanation: NEPA requires environmental impact assessments for projects that involve federal approval or funding. If wetlands are at risk, the Army Corps of Engineers must review permits under NEPA regulations. SOB protects species, but broader project evaluations fall under NEPA. C. Regulates air pollution, not construction projects. Marine Protection Act. D. Deals with ocean dumping, not wetlands. Relevant case: Robertson v. Methow Valley Citizens Council 1989, which reinforced the role of NEPA in environmental planning. Question 26. When developing a solution that must address opposing needs, a city council is debating whether to approve a major highway expansion project that would improve traffic flow but destroy a historic neighborhood. What legal process must the city follow to evaluate the project's impact? A. National Environmental Policy Act (NEPA) Environmental Impact Statement. B. Eminent domain under the Takings Clause of the Fifth Amendment. C. The Federal Highway Act of 1956. D. The Fair Housing Act. Answer A. National Environmental Policy Act, NEPA Environmental Impact Statement. Explanation The NEPA process requires an environmental impact statement (IS) for federally funded projects that significantly affect the environment, including social and cultural impacts. The city must conduct public hearings, analyze alternatives, and consider mitigation efforts before making a final decision. Eminent domain B. Allows the government to take private property for public use but does not assess environmental or social impacts. Federal Highway Act. C. Primarily funds road construction but does not mandate environmental assessments. Fair Housing Act. D. Protects against housing discrimination but is irrelevant to infrastructure planning. Relevant case. Robertson v. Methow Valley Citizens Council, 1989, reinforcing the NEPA in major public projects. Question 27. While investigating a complicated issue between different regulatory agencies, a pharmaceutical company receives conflicting guidance from the Food and Drug Administration (FDA) and the Environmental Protection Agency (EPA) about the environmental disposal of a new drug. How should the company resolve the conflict? A. Follow the agency with the stricter regulation. B. Ignore both agencies and follow industry best practices. C. File a lawsuit for regulatory overreach. D. Request interagency coordination under the Administrative Procedure Act (APA). Answer D. Request interagency coordination under the Administrative Procedure Act (APA). Explanation The Administrative Procedure Act (APA) establishes procedures for federal agencies to issue rules and resolve disputes. Companies can petition for interagency coordination to clarify regulations and avoid legal conflicts. Following the stricter regulation A might work, but it does not resolve inconsistencies between agencies. Ignoring agencies B is risky and can lead to violations. Filing a lawsuit C is premature unless the company has exhausted administrative remedies. Relevant case Massachusetts v. EPA, 2007, which clarified agency responsibilities in regulating environmental impacts. Question 28. During an emergency response where multiple areas are impacted, a state declares a public health emergency due to a chemical spill affecting the water supply. Residents file lawsuits claiming their property values have dropped. What legal doctrine is most relevant to their claim? A. The Takings Clause under the Fifth Amendment. B. The Commerce Clause. C. The Necessary and Proper Clause. D. The Supremacy Clause. Answer A. The Takings Clause under the Fifth Amendment. Explanation The Takings Clause requires the government to provide just compensation when it takes private property for public use. Courts have extended this principle to cases where government actions or emergencies significantly reduce property value. Commerce Clause B. Governs trade, not property compensation. Necessary and Proper Clause C. Grants Congress powers but does not. Property claims. Supremacy Clause D. Determines federal law priority, not property disputes. Relevant case Lucas v. South Carolina Coastal Council, 1992, where government restrictions led to compensation for lost property value. Question 29. In a multi-location scenario where consistency requirements must be met, a nationwide retail chain wants to enforce uniform employee policies across all stores, but some states have stricter labor laws. What legal principle determines whether the company can apply a single policy nationwide? A. State preemption doctrine. B. Federalism and the 10th Amendment. C. The Due Process Clause. D. The Equal Protection Clause. Answer B. Federalism and the 10th Amendment. Explanation The 10th Amendment reserves powers not granted to the federal government to the states, including labor laws and employment regulations. A national chain must comply with each state's labor laws, even if it prefers a uniform policy. State preemption applies within a single state, but not between states. Due process C. Protects legal rights, but does not regulate laws. Equal protection D. Prevents discrimination, but does not override state labor laws. Relevant case Wyeth v. Levine, 2009, which upheld state regulations despite federal policies. Question 30. While managing a hybrid approach where timing issues affect coordination, a financial institution is rolling out a new compliance system but faces delays due to differing state regulations on data privacy, which federal law provides. A baseline for data protection in this scenario. A. Gramm-Leach-Bliley Act (GLBA). B. Sarbanes-Oxley Act (SOX). C. The Securities Exchange Act of 1934. D. The Computer Fraud and Abuse Act (CFA). Answer: 8. Graham Leach Bliley at GLBA. Explanation: the GLBA sets federal standards for financial data privacy and requires financial institutions to protect customer information. However, states can impose stricter privacy laws, leading to compliance challenges across jurisdictions. SOX B regulates corporate financial disclosures, not privacy. Securities Exchange Act C governs stock markets, not data security. CFA D criminalizes cybercrime but does not address compliance systems. Relevant case: FTC v. Wyndham Worldwide Corporation 2015, which reinforced federal authority in data privacy enforcement.